Lawmaking. Evaluation of the purposive approach. The purposive approach to statutory interpretation is where the court seeks to find the purpose of the legislation before looking at the words. For a full explanation on the purposive approach, please see the video, The Purposive Approach to Statutory Interpretation. This video will focus on the advantages and disadvantages of the approach. Advantages of the purposive approach include: 1. It is a flexible approach. 2. It considers Parliament's intention, not just the words. 3. It closes loopholes in the law. 1. It is a flexible approach. The purposive approach avoids the uncompromising result attained under the literal rule. It allows judges to cope with situations unforeseen by Parliament. For example, with regards to RV Secretary of State for Health ex parte, Quinterval, Parliament in 1990 did not envisage that cloned embryos would be possible. This flexibility allows judges to develop the law to cover advances in medical science and new technologies. It also allows judges to avoid injustice, as seen in Pixton v. Freeman, where the judges were able to ensure the claimant's right to equal pay was protected. 2. It considers Parliament's intention, not just the words. The literal rule fails to recognize the complexities of language and allows a result which was never intended nor envisaged by Parliament. For example, it is most unlikely Parliament would have intended the outcome in R v Harris, where the defendant incurred no sanction for biting a person's nose off, or in Whiteley v Chappell, where the defendant escaped liability for using the vote of another. Looking for Parliament's intention should produce a fairer and more practical outcome. Allowing reference to Hansard in Pepper v Hart makes it easier for the courts to discover Parliament's intention. 3. It closes loopholes. An application of the literal rule can lead to loopholes in the law. This was seen in R v Harris, Whiteley v Chappell, and DPP v Cheeseman. Such loopholes could have been avoided had the purposive approach been taken. The purposive approach can also be used to prevent tax avoidance schemes. This was seen in Balhousie Holdings v HMRC. Disadvantages of the purposive approach include: 1. Judges become lawmakers. 2. It creates uncertainty in the law. 3. Difficulty arises in determining Parliament's intention. 1. Judges become lawmakers. Judges are given too much power to develop the law and thereby usurping the power of Parliament. For example, in Pixton v. Freeman, the law on equal pay was extended to cover work of equal value. In Quinterval, the law was extended to protect cloned embryos. Such extension of the law infringes the separation of powers. According to Montesquieu, it is Parliament's function to make the law and the judiciary's role to apply the law. Judges should not make the law, as they are unelected and not accountable. They have no power to commission research or consult with experts or the public. Lawmaking should not be in the hands of too few with the scope for judicial bias. 2. It creates uncertainty in the law. By moving away from the wording of Parliament, judges create uncertainty in the law. It is difficult to predict which approach the judge is going to apply. It also encourages litigation, as parties seek to enforce an alternative interpretation. Lord Mackay in Pepper v Hart highlighted how allowing reference to Hansard may lead to prolonged examination of irrelevant material by lawyers, which adds to the cost and length of litigation. Difficulties arise in deciding what was Parliament's purpose. The concept of Parliament's intention assumes Parliament has one intention. This is most unlikely, since Parliament is made up of 650 MPs and around 770 Lords. It also ignores the fact that Parliament is divided on party lines. This may mean judges are forced to choose between two opposing political viewpoints, forcing judges into the political arena. For example, in Bromley v GLC, the GLC, under Labour control, headed by Ken Livingstone, were under an obligation to run the London transport on economic lines. Ken Livingstone introduced a scheme to reduce pollution and congestion in London by reducing fares on tubes and buses by 25%. This was to encourage more people to use public transport rather than cars. To fund this, he put a levy on London borough councils. The Conservative-controlled Bromley Council challenged the scheme, arguing economic meant it had to be self-funding. GLC argued economic meant value for money, taking into account the value gained by lower congestion and pollution. They also pointed to the fact that the scheme was in their election manifesto and therefore they had a democratic mandate to introduce the scheme. However, the House of Lords held for the Conservative Bromley Council, holding that GLC was in breach of its fiduciary duty to ratepayers and that the judiciary are not bound by the wishes of the electorate. In summary, the purposive approach is flexible. It considers Parliament's intention rather than just the words and closes loopholes. However, it does allow judicial law-making, creates uncertainty in the law and can give rise to difficulties in what amounts to Parliament's intention. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.